Great. Can you hear me?
Loud and clear.
Fantastic. It already kicked me out once, so hopefully that's the last technical problem we'll have this evening. So, have you guys been
Busy. Lots
busy?
going on. Lots of
Yeah.
travel. Lots of work.
Yeah.
I'm not working,
Yeah, it's so great to be
but
retired.
but but don't tell Mrs. King,
Don't
please.
tell Mrs. K. Okay. Right. Yeah. I'm trying not to work, but I have so much going on. And for the last 2 months, it's been a lot of things. And so, as folks have noticed, we've been taking a break. The ship's been busy with some stuff. I've been working on some things of my own, and we've had a family issue come up that I've been dealing with. So, we've all been super busy. And as people I think know, we were going to be migrating to Substack, and we are doing that. I was working on that this week and last week. And so, as I put in the announcement for this, I think this is going to be our last spaces on Twitter. And we'll be doing these kind of more like podcasts over on Substack. So, I'm going to be putting out an announcement about exactly how that's going to work and where you need to go and etc. Sometime between now and Christmas. King and I are going to keep doing the JFK ones on here until we finish those up. But everything else will be migrating to Substack. So stay tuned for info on that. So with that all being administrative stuff being addressed, let's get started. Ship, you want to start with what's going on with Judge Boasberg? I think that was the main thing we wanted to talk about, but not necessarily the only thing tonight. Where to begin? I mean, most people probably, if they're listening tonight, listened to us earlier in the year talking about the the underlying substantive stuff, right? This has to do with the Trendaqua gang members and the administration's effort to deport them earlier in the year, which Judge Boasberg had issued some orders about. How much background do you think we should give folks on this, given that we've addressed it before?
Well, yeah. I think maybe we ought to disclose to all of those who've joined us to waste their valuable time that we have not done a lot of prep in advance of this session tonight. I had suggested it just a couple of days ago because there has so much been happening
Yeah,
on three or four fronts
yeah,
over the last 10 days. It's like, we haven't done one for a while
yeah.
for a variety of reasons. And man, it's just happening fast and furious. We should just jump in. So I think, everybody needs to kind of indulge us a little bit that
Yeah,
this is going to be a little bit
it's going to be
scattershot.
a mess.
Um, yeah.
Not like our
And,
usual streamline approach.
let me go back to the beginning on this
Okay.
and just do a Reader's Digest version, dating myself and King, what Reader's Digest
Yes.
means.
Uh, I
Um,
remember that. I
uh,
was a kid. We had that in the
yeah,
house. Yeah. I haven't seen one of those in decades, I don't think, though.
yeah. So this began with the proclamation that Trin de Agua were alien enemies of the United States, subject to immediate summary deportation under a particular statute dating back to 1791, I think, or 1792, where the president simply issues a proclamation that we are in state of conflict in some measure or form. I don't have the language of the statute in front of me, and therefore any nationals of that hostile country inside the United States are subject to immediate removal. And so on the night of
March.
March
Yeah.
15th, there a bunch of Trendagua Venezuelan gang members began being processed and moved towards flights that were going to be departing the United States and headed for El Salvador because Venezuela had suspended repatriation flights of Venezuelan illegal aliens in the United States and would not accept them back into Venezuela. So after a week of that, the Trump administration said, "Oh yeah, we'll see and raise you
Mm.
we're going to send him to an El Salvadoran prison, and we'll see how much
How
you're,
much you like
national
that? Yeah.
like that.
Now
So,
there were
um,
a couple of limitations. The person had to be at least 14 years of age. They had to be a member of this gang.
correct, correct.
Yeah.
Um, so then, and this is also complicated by the fact something that I don't think any of us appreciated at the time, but now it's cross pollinated to some degree with the entire temporary protected
Yeah.
status situation, because there's 600,000 Venezuelans in the United States covered by temporary protective status. And this is understandable in the sense that it was actually President Trump in his first term that gave TPS to Venezuela because of the collapse and illegitimacy of the Maduro regime.
Yeah, their society
Basically,
was in total meltdown.
yeah, so it was basically an act of, it was, in some ways, a
Hmm. Yeah.
humanitarian gesture
Yeah.
towards Venezuelans in the United States, saying, look, we're not going to
girlfriends or
give you back
fiance or
Venezuela
nieces.
because
I
it's
just
a
want to
failed
make
state. It's a
I mean, I
narco
don't know if
terrorist
people
state.
remember that. I mean, people were, trolling garbage uh, dumps for food. It was the conditions there were horrifying.
Yeah,
So
and if you're, for those of us that are a little bit older, you go back to pre-Chavez, Venezuela was one of the crown jewels of South America.
yeah.
It had huge oil reserves. It was a wealthy South America, or by South American standards, it
Hmm.
was a wealthy country that had a robust, legitimate economy. It wasn't Colombia narco, economics.
Right.
It's closer to Argentina and in
Hmm.
some ways to Brazil.
Brazil. Yeah.
Uh, and so then it just becomes, though, under Chavez, who was a committed communist, nationalizes all of the industries and just makes it a complete, a mess, a wreck.
Yeah, like a living
And
hell. Hmm.
right, and persecutes his, political enemies, and imprisons the opposition, and all of the stuff that you see in, third world despotic communist nations. Okay, so that's way off track. So Judge Mosberg had tried to put a stop to these two planes while they were en route. He gives an oral order from the bench. Well, it was a Zoom hearing, so colloquially speaking, from the bench, an oral instruction, and tells the government lawyer, who, by the way, and I've written about this now, wasn't just any old government lawyer who wandered into the Zoom hearing. It was the Deputy Assistant Attorney General of the Civil Division
Right.
supervising, and it's like, you don't see Deputy Assistant
No, they
Attorney
they don't
Generals.
show up in the district court that often. Yeah.
Right, and it was a reflection. This was on March 15th. It was a reflection of the staffing of the Department of Justice at the time. You're 8 weeks or so into the Trump administration, and you had just massive resignations out of the Department of Justice. So on a Saturday night, it's like there's nobody else to do this. The Deputy Assistant Attorney General is going to do it.
Right.
So,
Plus, it involves complex immigration law, and it's not like your average AUSA in the civil division is going to be up on that.
well, and this guy, Drew Ensign, had only joined DOJ in January
Mm.
at the beginning of the Trump administration. He had been in the uh, Arizona Attorney General's office as a Solicitor General, and had a background in immigration law.
Right.
So, in Arizona, so he knew the subject matter. Um, so then where so Judge Boasberg gives an oral direction from the bench to Drew Ensign that includes the phrase "turn the planes around and don't disembark the passengers," meaning that, what Judge Boasberg's view was, while they're on a U.S. chartered aircraft accompanied by U.S. government law enforcement, they are in the custody of the United States, and he is ordering them essentially to not leave the custody of the United States. Turn the planes around or bring the people back. So,
And we talked about
but
it at the time how insane we thought that was.
yeah, and he, because he had, and it was insane because, and I was listening to this hearing live on that Saturday night. I was interested to hear how it went, so I'm listening live, and he did it because he just, willy nilly ran through class certification like it was just, checking boxes on a form.
Right.
and certified a provisional
Mm,
class, and then declared everybody on the planes to be part of the
right.
class, and then subject to his TRO that they not be removed. So
Blowing
while
by
he's
whether
been
he had or didn't have any jurisdiction of the thing in the first place.
exactly, just it was quite literally Judge Boasberg, who I know and you
Yep.
know, we both appeared
Yep.
before
I've
him.
known him for a long
He
time.
is he
Yep.
he's not an irrational guy. He's very measured in his approach, and generally very thoughtful. But this was an instance of Judge Boasberg giving in to his progressive instincts, which were, I've got to do the right thing
Right.
at this moment to preserve my ability to do the more right thing later,
Right. So it's just all outcome
which is
determinative. Yep.
exactly yeah, it was means to an end. The class certification. Oh well, I'm not going to let myself be troubled by that. Jurisdiction. We'll work that out later.
Right.
The important thing now is that we get these people back.
Right. I mean,
Um,
his view of jurisdiction at that time probably was, well, it's a federal issue, so
well, it's an APA
right.
claim, and the defendants were in the District
Right.
of Columbia.
Yeah.
So, so everybody knows that APA claims are, against the administration are filed in the District of
Right.
Columbia. Uh, so, but he also makes an interesting comment during the hearing in a very Boasbergian fashion. He says to the lawyers who he can see on the screen, he says to them in an effort to, yeah, I mean, I heard it in an effort to be friendly. He says, "Don't worry about writing this down," because he can see they're scribbling notes.
Right.
He says, "Don't worry about writing this down. I'm going to issue an order shortly after we're done here, and it'll be clear."
Right.
Okay, well, yeah, I've heard a judge say that 1,000
Right.
times.
Yeah.
It's
And
I'm
so people understand this is because the law is the courts speak through their orders, at least in federal court. This is not always true in the state courts, so don't take it as a universal concept. But in federal law, an order has to be written so that everyone can see and understand exactly what the court has ordered to be done or not be done. And until that written order issues, there's really no order.
right. And so that's the end of the hearing. And then 35 minutes later, he issues a written order on the docket of the case. But the written order on the docket is like two sentences. It's not anywhere near as not verbose, but it
Detailed.
doesn't have the
Yeah.
detail that he was giving from the bench. And I think on the bench he was just he was speaking off the top of his head, saying, "Do this, do that." The order itself says, "No member of the class shall be removed for 14 days." Well, government looks at that and says, "This group's already been removed."
Right.
The order is written prospectively. For the next 14 days, there shall be no additional removals. And it does not say anything about turning the plane around or bringing anybody back.
Just to be clear, it was while he was talking on the bench, the uh, the planes were being filled up and in the process of taking off. So it's not like the government didn't do their best to get those people off the ground and quote removed, close quote.
Well, and in fact, Judge Boasberg has made that point recently in some of his written things. And in some of the hearings, and I've gone back and reread the transcripts. He said, "Look, you guys were working as fast as you could to try to get these individuals out of the country before a court could interfere." So, he's essentially saying you were actively seeking to avoid or evade any judicial scrutiny of what you were doing. One of the things he points to is that the necessary machinations to get all of these people in the right place to get on the planes that day, the 15th, began in the morning, but the president did not issue the executive order invoking the AEA until 3:30 in the afternoon. But in fact, he had signed it on the 14th, but it wasn't published on the Federal Register and posted on the White House website until 3:30 in the afternoon on the 15th, and the planes were basically being fueled and ready to go, and they took off between 5 and 6. So, Judge Boasberg's, point was you waited until 3:30 to tell anybody you were going to do it, and by 5:30 you had planes in the air. So you left this very small window for anybody to know what to do or to take action. So it was like you're too cute by half,
Yeah.
and by being too cute by half, I'm not giving you any credit for regularity.
I don't really think that that's too cute by half. I thought then and I think now, so what? Right? The
I agree.
government,
I agree.
so what? The government is doing what it's doing. It's either right or wrong, right? Um, and they either have the authority to do what they're doing or they don't. But they don't have to wait around to see if a judge is going to bless everything they think they have the authority to do.
Correct. Now, so let's push the story around a little bit. Eventually, Supreme Court steps in and basically says that Judge Boasberg did not have jurisdiction. That these
Yeah.
are claims. And the phrasing is sounding in habeas,
Right. That they were
and
not APA case
correct,
claims. Yeah.
correct, and that claim sounding in habeas could only be brought in the location where the claimant is physically located, in a court in that location. And all of
Which
these
wasn't
subjects,
the district.
correct, all of these individuals were in Texas at the time because that's where the planes departed from, and that their claims sounding in habeas had to be filed in either the northern or southern district of Texas, just depending on where they were at a particular given point in time.
Well, the lawyers didn't
So
want to do that. Obviously, that's why they filed it as an APA claim.
correct. So then that, in some ways, now Judge Boasberg, he's held on to this case
Mm-hmm.
by some continuing efforts by the plaintiffs to file a First Amendment complaint, a Second Amendment complaint, to try to state some theory of liability on the government's part that would give jurisdiction in the District of Columbia, at least to some small number of plaintiffs. I really haven't tracked that. I know
Mm-hmm.
it's still pending.
Right.
There's motions to dismiss that have been filed, um, and so that's kind of the B roll. What's still going on before him. The A roll, the A story, is now a continuing effort by Judge Boasberg to conduct a criminal contempt inquiry of various Department of Justice or Department of Homeland Security officials as to whether they willfully defied his TRO issued on the evening of March 15th. As reflect now, as he's, somebody's going to ask, or nobody's going to ask, but I'm sure people are thinking, but did he ever make his TRO clear? Well, the answer to that question is he's never explored what his TRO actually said and what it required people to do. He's continuing to conduct an inquiry of what they did, but has yet to compare what they did to what they were obligated to do, because that would require him to explain his TRO, which he hasn't done yet, at least not that I've seen.
Or have to grapple with this issue of you want to hold them responsible for what you said from the bench instead of what's in your order.
Correct. And there's this, excuse me, there's a line of cases. Judge Lamberth in D.C. has written one that says basically what a judge says from the bench is not an injunction.
Right.
And because it's what, as you mentioned, it's what the judge writes down that becomes the injunction. And there's a line of cases in California, the Ninth Circuit, that talk about, that has to be the rule,
Yeah.
because until the judge puts pen to paper, you can't say that the judge has completely finished his thinking. That you can have an argument on the bench, or you can have an argument in court, and the judge can say things that tend to telegraph what his decision is going to be, but he can go back to the chambers and do some more research, or look at some
Well,
documents,
judges change their
and
mind 3 or 4 times in a hearing sometimes before they
right.
arrive at a final conclusion.
And they don't need to. It's not like it's not necessarily 180-degree
Right.
yes to no and no to yes.
Right.
It's just a formulation of what their order is going to be. Doesn't become finalized until they sit down, write it out, and hit, enter
Right.
on the computer. Then it becomes an order. Then it appears on the docket of the case, and everybody knows exactly what it says.
Or you have an
So,
Now,
argument that it's vague and you can't comply with it because it's unclear, right? It's a
right.
starting point, but before that starting point, you can't be held accountable to it. That's what the law says.
now,
Okay.
let me jump in. Before you even get to that
Mm,
issue, you have a basic question that there is case law answering it, but you do have a basic question. How in the world can a court that has no jurisdiction issue an order that makes people comply with it lest they be held in contempt?
right. This case law is very unsatisfactory, in my opinion.
Yeah. Well, I mean, so Judge Boasberg, they had a discussion during the hearing as to the court's jurisdiction, and he acknowledged at the time that his jurisdiction, you know, was in question. That the government argued that these claims sounded in habeas, and therefore the habeas rules applied and should be filed in a different district, and he acknowledged that argument. But he simply came to a different conclusion.
Right.
He came to a wrong conclusion about his jurisdiction,
Right.
and the Supreme Court ultimately settled that. So, I mean, hell, I mean, if we just if if we invalidated from the start every decision a judge gets wrong,
Right.
we, that's all we do, because they get a lot of stuff
Right.
wrong. Um, and he got this wrong. He got this wrong as a kind of as we discussed at the outset, sort of a product of his default mindset of, we'll work out jurisdiction later. First, we got to put a halt to this abomination of
Right.
justice.
Now,
So,
King, you want to
um,
address what the case law is on, but how does it make sense that, yes, you have to follow a judge's order even if it's wrong? How does that make sense in the context of the judge not even having jurisdiction?
It I can argue it either
Mm,
way. That the jurisdiction issue, if the court doesn't have jurisdiction, the you can make a case that everything the court does has no effect, and therefore you cannot punish somebody for violating orders. The other side of that argument is that to be effective, uh, to, to to create a judicial system that has any teeth at all. You have to, at a minimum, require persons before it, not outsiders, but persons who are in the court to obey the orders of the court. And if they don't, it leads to chaos.
right.
So we have to enforce those orders regardless of whether they're right or wrong, regardless of whether the court had jurisdiction to issue them.
Until a higher court says that there wasn't jurisdiction, and then you're
R-
relieved of your obligation to comply, is what the current law says.
Right.
Yeah,
So
that's
so
for so
so
people understand. That's if whether the court has jurisdiction over the case. There's a different line of cases that sometimes goes the other way when the question is, does the court have jurisdiction over you? You guys know what I'm
yep.
talking about?
No, no, I
yes.
agree. Yeah, yeah.
Yeah,
Personal jurisdiction opposed to subject matter jurisdiction.
right,
Um,
right,
you know, okay, so let's returning to our story. So Judge Boasberg, so he the actual merits of the case and whether these people are removable and what due process rights they have before they can be removed under AEA proclamation. That sort of all gets shifted away from Judge Boasberg into other courts, but he's continuing, and on April 16th, I think it was the 16th, he issues a 40-page order finding probable cause that some unknown Trump administration official had committed criminal contempt. by failing to turn the planes around. Um, and again, now I haven't gone back and looked at that. I'm going to guess somewhere in there he does, at least in some minimal fashion, grapple with what his order really meant and what
Yeah,
they were obligated to do,
he did.
because he would have had to in that decision. But where that stood, where that left the issue was he hadn't he hadn't yet explored and gotten an answer as to who made the decision.
Right.
Um, so he essentially came to the conclusion that somebody had acted in a contemptuous fashion, and would be potentially open to a criminal prosecution for contempt, which can lead to a period of incarceration. He just didn't know who yet. So further inquiry was needed. Well, before that further inquiry could take place, the Department of Justice sought a writ of mandamus from the appeals court. And the appeals court, and I still cannot figure out how the Trump administration keeps coming up 2-1 on all of these panels when there's only four Trump
Appointees on that court, right?
appointees, and I think what are there 7? Is it 11? 11 on the court?
Think so, yeah.
Yeah, it's 11. So they're outnumbered 7-4, but they keep coming up with 2 Trump appointees on these panels.
Right.
So one of the panels stays his issues a stay on his intention to continue to pursue this contempt inquiry, and months later, is in August, I think, the panel reverses his finding of probable cause for contempt, but in a very odd manner. There's 3 judges on the panel. It's Judge Walker, Judge Rao, both Trump appointees,
Right.
and I believe Judge Childs was the third one in. Could be wrong, but I think it was Judge Childs. She's the third one in today.
That
On the
sounds
order that
right.
came out
Yeah.
today. So, and I think it would be the same panel all the way through. I think they would be consistent. So the way that panel decision comes out, though, is that Judge Rao and Judge Walker reverse the issue of writ, instructing Judge Boasberg to not go forward, but for different reasons. Judge Walker finds that his order was not sufficiently definite for any criminal contempt to have taken place. It was imprecise, it was vague, and it was contradictory, and so it doesn't matter what his finding might be. You just can't reach contempt based upon what he's already found. So Judge Walker would have just ordered the whole thing being dismissed. Judge Rao, on the other hand, has a completely different view. She finds that the criminal contempt inquiry is appropriate. However, she found that Judge Boasberg's he gave the government a choice in his probable cause finding. He says, your choice is to tell me who the responsible official is, or to cure the contempt, bring everybody back. If you bring everybody back, we won't go forward with the contempt. We'll just, we'll call it water under the bridge, and we'll go forward with their due process
Which is
claims.
sort of like judicial action via threat.
Well, that's exactly what Judge Rouse said. Now, interestingly, what Judge Rouse said is that's improper
Yes, very.
because, well, it's why she said it though. She said it's improper because the Supreme Court found you didn't have jurisdiction. So in effect, offering this compromise is enforcing your TRO, which the Supreme Court said you didn't have authority to issue in the first
Right.
place. So she said that was essentially an
Which is different
illegitimate.
from saying I'm punishing you for not doing it.
Right.
Yeah.
So what she said is that made his probable cause finding illegitimate, or she didn't use that word, but
Mhm.
um,
Ineffective, let's
yeah,
say. Yeah.
ineffective, and but said, but we're going to send this back. This is where she joined with Judge Childs, sending it back for you to start over.
Do it the right way. Yeah, if you can.
You can't. You can do a criminal contempt inquiry, but you can't offer this kind of choice or bargain to the government to escape the contempt. If they engage in criminal contempt, you go that direction. But you don't have the authority to use your threat for a criminal contempt inquiry to get to compel them to comply with an order you weren't authorized to make in the first instance. So that sat, that takes us from when he issues a probable cause order in the first instance in early April. I think that three-judge panel decision, which was actually different.
Uh, um,
Okay.
yeah,
So I had a call come in. I just declined it. So you had essentially two-one decisions with Judge Rao shifting positions. First with Judge Walker, and then but with she also the only thing she agreed with Judge Walker was on the
right,
outcome that it should
right,
go back. Judge Walker would have sent it back with an order to
right. Just stop.
dismiss.
Just stop,
Uh, she
Boasberg. Just
she said
stop.
right. She sent it back with an order to
Right.
start over. So, but then there was another pause. That was back in
Meanwhile, the
August, and
Supreme
then there was a
said
pause.
that the president's proclamation could be the subject of judicial review for at least some things, like, are you 14 or over, right? Are you actually a member of this gang? Because the government's position was there was no judicial review at all to be had. And the Supreme said that's not
Right.
right. Although that also is a separate question from jurisdiction, right? That was more like justiciability. So,
Yeah, and that yeah, and they were relying on the post World War II
mhm,
case. I can't remember the name of it from
right,
1947, where the Supreme Court in that case said in a footnote, of course, alien enemies have certain due process rights that they are a citizen of the country, they are older than 14, and in the Venezuela case, they were members of
right.
Trinidad.
But what's
So,
interesting
but
about that
if I'm
is
not
that
mistaken,
the government was taking a very hard, I mean, you could say extreme, I think maybe I won't use that word, but they were taking a very specific and hardline legal position. And the Supremes said that that position was wrong. But to me, if you're a judge and you're looking at whether you're going to hold these government officials, some of them government lawyers, in contempt for violating your order, I think you have to take into consideration, well, what was their legal position? Right? This isn't a run of the mill case where they've just decided to flout the court's order. They were telling him the whole time, we don't think you have the authority, the constitutional authority to interfere with us doing this.
well, and it was part of, this is we're talking
Hmm.
about back in March. It was part of a very expansive reading of
Right.
Article Two authorities, and to the extent that it was very much an extreme.
Expansive, let's
Extreme.
say.
I don't want to say extreme. Yeah, an extreme argument as to look on a separation of powers basis. There's some things you just don't get to second guess
Right.
the executive on. And we're not just a separate branch of government; we're an equal branch of government. You're not
Right.
my boss,
Right. Which to me,
so to
this
speak.
has to factor into whether this is contempt or not. Right? These are not just lawyers or sit parties before the court saying we don't like your order and we're just not going to fucking follow it. Screw off. That wasn't the situation. The
Well,
situation was they were telling him, with respect, Your Honor, you don't have the authority to tell us any of this. Now they were wrong about that, according to the Supremes, but it doesn't feel like contempt to me.
well, and I think, and that's a point that we've had discussions about in the past. That a lot of these, there's a lot of criminal contempt case law out there, but it's not criminal contempt against members of the
Right.
executive branch, or in the context of the AEA
Right.
against the president. He's the one that issues the proclamation and says,
Right.
"Get these people out of here." And I think I've taken kind of a more strident position
Hmm.
among the three of us. And Steve formulation of what their orders is.
Just that just the
Was that it's the president is
yeah,
different. Like no man's above the law. Bullshit. The
right,
president is different. He answers to the voters every 4 years. If you don't like the way he's managed his job, then that's the remedy. And short of that, Congress
right.
can impeach him,
But other
but
than
he
that,
still
he's
gets to
cloaked with
make
constitutional
decisions.
power to do shit, and the fact that you don't like it is irrelevant.
Exactly, exactly. And the Supreme Court the same
Yeah,
way. Not necessarily Article 3 judges sitting down in the
right,
district court. They're creatures. They're creatures of Congress. They're not. They are not the judicial
right,
branch. The judicial branch of the Constitution is the Supreme
right.
Court. Um, so so this sits. So this goes to the D.C. Circuit Court of Appeals. You have this kind of goofy 2-1-2-1 decision, but then there's a call by some judge on the Court of Appeals for an en banc review, en banc reconsideration of the panel's decision. Now that sits for 2+ months, and at the end of the day, it comes out very curiously. It's 6-5, I believe, against, or no, actually I think it was 8-3. It was 8-3 against review. In other words, leaving the kind of goofy 2-1-2-1 decision in place. And there's an opinion written by I think 3 of the judges that basically says, look, we don't like this
Mm,
outcome. We think it should be reviewed, but we can live with it because it's going back to Judge Boasberg. He just has to start over and not have that
right.
defective feature.
Decision by a
And
threat
so
is
the
not doesn't work. Do it the right way. Yeah.
extortion, yeah. So it's so they allow it to go back to him, and Judge Rouse, or they in effect let the goofy 2-1-2-1 decision from August stand. And that includes Judge Rao and Judge Childs sending it back and saying,
And
start
at
over.
that point, I wondered if he might just drop it because there's a long history of judges doing contempts that are stupid, where they've the power's gone to their head or they have lost their temper temporarily or whatever, and they really should just quit. They should just stop, right? And occasionally you will see a judge will do that when the appellate court sends it back. The judge is like, "Yeah, I've moved on to other things. We're just this case
Right.
is
Well,
over,"
yeah,
but he didn't do that.
yeah, I was mad about
Yeah.
this in April, and now it's
Right.
yesterday's news. Well, and I have a theory
Okay.
about this. I, I am, you know, knowing that courthouse, in the 3 years I spent there, I suspect there are some voices in his ear urging him to go forward, that he needs to lay down a marker on behalf of that court, which has to hear so much litigation involving the administration. That their orders are important because they have so much litigation involving the
Yeah.
administration, and they must
Right.
be respected. Um, other courts don't
Right. They
have
don't.
as much non criminal
Where the
litigation
government is the
involving
party.
the United States.
Yeah.
And so I think there's this sentiment, and I'm not, I don't have to spout off names of judges, but I mean, you and I could probably come up with the same
Yeah.
6 most likely candidates who are in his ear saying, you gotta stick it to them. You
Right. They
got
can't do
to
this to
make
us.
it clear that they have
Right.
to listen to us. Um, Now, I also think that, well, let's go forward to, so what's happened. So they send the case back to it. Well, the first thing he does is he asks the parties to propose how they should reinitiate, go forward. And both sides agree, let's just get, declarations about the events of the day. And then once we have the declarations of the people involved, we can decide,
Right. Let's see
next
what the
steps.
facts are first.
And
Right.
so he issues an order, and it was in late November, and it says, that by November 25th, the government shall submit declarations of all officials involved in the decision to not turn the planes around, or I can't remember exactly, but the involved in was, or and their, oh, I know, it was involved in and their role. Describe, anybody that was involved in, describe what their role was. And I'm reading this up thinking, that's going to take like 3 sentences. It's like, what's involved? Who's involved in? You could really reduce that to like 2 people. And then what was their role? He didn't ask them for a narrative explanation of what they did and what they decided. He asked what their role. So he got back 4 declarations, 3 initially and then 1 more later. Secretary Nome,
Right.
DHS Secretary Nome, um, Deputy Attorney General Todd Blanche, and the acting general counsel for DHS at the time, which is Joseph Matarazzo or something similar. I'm butchering his last name, but Italian last name. Um, and and Blanche and Matarazzo basically said, I was Deputy Attorney General. I received information. I provided confidential legal advice to Secretary of Nome, and Secretary of Nome made a decision. And Matarazzo said the same thing. I was acting general counsel for DHS. I was provided information about the court's TRO. I spoke with Secretary Nome and gave her legal advice, and Secretary Nome made a decision. And Nome's declaration said, I'm Secretary Nome. It was my responsibility on how to handle I was given legal
Right.
advice from the Deputy Attorney General and the General Counsel, and I decided the planes should continue on. And that was all Boasberg
Right.
got, but those answers were responsive to the
Right.
question he asked. So now the consequential one though comes the following Monday. Those were all on Friday, the day they were due. It might have been the 28th of November, but then one comes in on Monday, 3 days late. It was supposed to be in on the Friday, but it comes in on Monday, and it's from
Well, the
now.
courthouse was closed the day
Sir,
after Thanksgiving, so.
right. But now this one, the last one comes in from now Third Circuit Judge Emil Bove,
Hmm.
who was the principal associate deputy attorney general. So he was Todd Blanche's basic
At the
right hand
time.
man. And yeah, at the time. Now he's since been nominated and confirmed as a judge on the Third Circuit Court of Appeal. A level of judicial authority one step above Boasberg, but in a different circuit. And it basically says I was the principal associate deputy attorney general. I received certain information about the court's order. I consulted with the deputy attorney general and Secretary Nome and provided her confidential legal advice. And that's all he said. So, so Judge Boasberg then issues an order following the submission of those and says, having received the
Yeah.
cursory declarations from the government telling me nothing other than I now know that the final decision was made by Secretary Nome. However, I cannot evaluate from the information provided her state of mind. And the offense of criminal contempt requires a willful state of mind, meaning that had an appreciation for the illegality of the action she was about to take and took it anyway. And so he then says, we're going to have testimony from one government lawyer and one former government lawyer, so that I can gather more facts that will allow me to form an opinion as to Secretary Nome's state of mind, all in this endeavor to reach a probable cause determination as to whether Secretary Nome, now she seems to be the only one at issue because she said she made the decision. Um, and so to make a probable cause determination as to whether she, committed a criminal
So he
contempt.
somehow thinks he's going to
But
put Emil Bove on the witness stand. Oh.
not both. He's bringing in, he would proposed to bring in Drew Ensign, who the
Oh, I
Deputy
see.
Associate
Okay.
Attorney General, who made all the appearances, and this other attorney, um, as what Ruvani, the guy that got fired. He got fired over the Kilmar Abrego
Right.
Garcia case. But what's his first name? Reza,
Something like that.
Reza.
Rizzo, yeah.
Uh, yeah. Um, and and the reason he came to light is because after he got fired for his conduct in the Kilmar Abrego Garcia case, he filed a whistleblower complaint the day before Judge Bove was set for his confirmation hearing. And he says in his whistleblower complaint that there was discussions among DOJ lawyers prior to Judge Boasberg's order. So on the 14th, when they were discussing, the mechanism for implementing the anticipated AEA proclamation, that there were conversations about what are we going to do if there's an effort by a judge to interfere or prevent us from sending these people out of the country. And he attributed to Judge Bove the phrase, we'll have to be prepared to tell a judge,
Right.
fuck you. Or, that's just my characterization. But interestingly, when you read his whistleblower complaint, the only quotation is the fuck you phrase. Everything around that is not a quotation, it's a characterization of what he claims Judge Bove said
That's his
during
short
these
form
discussions.
paraphrase.
Right. But the fuck you is in quotes. In other words, now, this is on the 14th. There's no Judge Boasberg in the mix. There's no judge, anybody in the mix, because the proclamation hasn't been in, no lawsuits.
They're just thinking ahead to what are we going to do?
Right. What are we going to do? And so Judge Boasberg wants testimony from him, who is now that he now works for Democracy Forward, a left wing,
Right. Of course he does.
progressive interest group that advocates. Well, this is the great part is. So this guy is promoted. He Department of Justice employee for 15 years, been there a long time. Promoted. He's the acting director of the Office of Immigration Litigation at the time. Been promoted to the acting. He'd been the deputy director and promoted to the acting director, and that's a couple of steps below the deputy assistant attorney general. But when he leaves, when he gets fired, he goes to work for an immigrant interest group, immigrant rights interest group. It's like your job's deporting illegal aliens
up until 5 minutes ago, right? Yeah.
And then as of Friday, this past Friday, he's now represented by Michael Bromwich. And there probably is very few more devoted Democrat partisan lawyers in D.C. than
he
Michael
represented Christine Blasey Ford, so people know.
Yep, and Andrew McCabe. So when I actually had a case with Mike Bromwich, I know it a long time ago, but I spent a lot of time talking to him. So that was what Judge Boasberg's intention was last week, was to have, and he's going to bring, and it's like, and there were questions raised about what are a lawyer who didn't talk to Christine Home, provided no advice because he wasn't in the conversations, and the deputy attorney general, or the deputy assistant attorney general, who has said all I did was pass on the court's order in both the oral order from the bench and the written order, and it went up the chain of command, and then I didn't learn about the decision until the next day. So it's like, what testimony are they going to give you that will inform you as to Secretary Noem's state of mind at the time she made the decision? Now, I don't know if you saw this earlier today, and so the government went back to seek a writ of mandamus to put this all off.
Right, because they think it's insane. And you got attorney-client privilege issues here, right? You've got a lack of due process, they assert. Now, King, you were talking about this angle in our private conversation. Because, well, the government characterized it in their mandamus position as basically a circus, along the lines that this is just a fishing expedition, to your point, Ship, which isn't going to take this judge anywhere because this guy didn't talk to the secretary, who's the one who made the decision.
Right.
So
I think it is going to take him. And this is sort of what I predicted in the article I wrote last week. Is I think this was he was simply going to mine for more outrageous government activity. But at the end, and he was going to write a 60-page scathing opinion. and include all of this anecdotal information where he simply discounts any good faith or intentions to comply on the part of the government, and talks about how they were too cute by half. This whole thing about the proclamation not being issued until 3:30 and the planes already being gassed and ready to go, and all of this was just an effort by the government to circumvent
Right. Or, well,
FIPA.
or judicial review at least.
Right, right. And but at the end of the day, he was not going to be able to find willfulness on the part of Secretary Nome, so he would not recommend criminal contempt proceedings.
I think
I
so
think that's
too.
great.
It was going to be a big look how terrible this all is. But on a
Exactly.
technicality,
It was
I
going to be a
can't
big
hold her in contempt. So, oh,
right, right. Because I think the big problem for him is the contempt is going to wrap around back to Judge Bove. And that's the
right.
last thing he
Yeah.
wants to do.
Well, and you've got the problem that I'm raising that their legal theory was that what they were doing was lawful and authorized by the Constitution. That's not willful contempt of his order.
Yeah,
Right.
yeah. Ship, tell everybody what happened today. I think that's the critical part.
Well, right. So after on Friday, a panel of the D.C. Circuit, the same three judges on a 2-1 vote with Judge Childs objecting, they issue an administrative stay putting off today's hearings. Was supposed to start today. The first witness was going to testify today, and this is actually kind of interesting. I thought I'll mention just briefly. He was going to have Ravini or whatever the guy's name. He was going to testify starting at 2
And
o'clock
who
this
was going to
afternoon
question
to
him?
be Oh, I'm
The
sure he
judge.
was primarily, but also he was going to allow the ACLU. He was going to allow the ACLU. So, and then, but he's already got the guy's
Yeah,
whistleblower complaint. So he's got a roadmap to what his questioning was going to be, and he was going to get that story out
right.
first. Then, Deputy Assistant Attorney General Ensign was set for 9 o'clock tomorrow morning. Well, that was going to be all cross examination. That's how he was setting it up. Is I'm gonna establish what actually happened, and then I'm gonna start undermining the explanation offered by the government's lawyer. And so Friday, the three-judge panel issues a stay, and Judge Boasberg then follows it up with an order vacating the hearings that were set for today and tomorrow. Today, however, the three-judge panel, same three judges, issue an order directing, setting up a briefing schedule on the writ of mandamus, giving the petitioners. So it's going to be up to the ACLU, but then raises the question whether Judge Boasberg will file anything in his own defense. Giving the petitioners like 2 weeks to file their opposition, and the government a week after that to file a reply, but directs them to address the question of whether, in a case of indirect contempt, where the contempt conduct or the alleged contempt conduct is outside the view of the court, doesn't happen in the courtroom. In that situation, is it appropriate for the judge to essentially conduct the
Right.
discovery, in
That's
quote,
my
the
point is
investigation
he's
himself?
formulating the demands that have resulted in the return of these affidavits. Now he's going to haul witnesses in front of himself and question them for the benefit of himself, with himself doing the questioning. And when you're a judge and that's what your plan is, you should probably stop, because none of that is the way
Right,
that's supposed to work.
It's not just
right,
supposed to work.
Eh,
It goes back to the founding fathers
yeah.
that created a judicial system based upon the English common law, which was different from the way courts ran in on the continent of Europe. You have the common law courts where the judge was the neutral decider in what's in the Constitution, cases and controversies involving two opposing parties. It's an adversarial system. The presumption is the law is best served when you have side A against side B and a neutral decider hearing both sides, giving both sides due process of law, and then either the judge or the jury or both deciding what the facts are and deciding how the law applies to those facts and deciding the case. And in contrast, the continental civilian uh, tradition had the judge act in an inquisitorial fashion. The judge became involved in the investigation,
And they
became
still do it that
involved
way in Europe.
in many countries, yes. And that is not an adversarial process, but the judge is more of a magistrate who goes out and does discovery, hauls people before him to testify under oath, and then decides whether the case should proceed to a criminal trial. That's what Judge
Hey, King,
Boasberg is doing, really.
yeah. Let me ask you, King, and Leslie, maybe you can pull it up if you've got your computer handy. I wrote a Substack that addresses this issue just last week, and Judge Scalia, there's a Supreme Court case from like 92, 87, maybe 87, 92, on this question of empowering a private party to act as the prosecutorial authority in a criminal contempt setting. And with the in this particular case, the Supreme Court ruled against it because the judge had appointed the lawyers for the adversarial party to conduct the criminal inquiry or contempt prosecution of the opposition's lawyers
Right.
for violating it. I can't remember. I think it involved Louis
Oh,
Vuitton. It was a
yeah.
trademark infringement or trademark infringement case, I think, for Louis Vuitton. But if you can pull up my article, Judge Scalia concurred in the outcome because the outcome was that this was an inappropriate criminal contempt proceeding by appointing opposing
So
counsel
prosecute the
to
other lawyer. Right.
prosecute the case against the other lawyer. Um, but Scalia writes a concurring opinion where he basically just throws up his hands and says, this is all nonsense. We should not be authorizing judges to do this. And he really lays waste to the rationalization employed by the courts for criminal contempt, which is we have to defend our own authority. We have to take steps ourselves to make sure that people obey our orders. And and and, and Scalia says, what makes us special? He says, Congress passes laws, but the president doesn't have to prosecute him if he doesn't want to. That doesn't give Congress the prosecutorial power because the president, won't do it. And and he says, and the president has the power to prosecute law violators, but if Congress doesn't give him the money, that doesn't mean the president could go out and raise his own money to prosecute people. So why is it that the judiciary is special, that if people don't respect our orders, we suddenly have the prosecutorial power to prosecute them ourselves?
Well, I mean, the answer is
And
because historically it's always been that way in our system that
But
the argument is the courts need to, in extraordinary circumstances, be able to hold people responsible for not following court orders. Otherwise, the court system doesn't work. Now, you can accept that rationale or not. But here you have the additional issues that not only do you have a direct contempt, which the cases clearly say a judge can hold you in contempt if you engage in conduct that's contemptuous of the court right there on the spot, right? Somebody who tells the judge to his face, fuck you and the horse you rode in on. Um, but this indirect contempt can be prosecuted, but in our system, there's a statute that says the judge is supposed to refer that matter to the prosecutor's office to see if they want to prosecute it. And Boasberg is kind of here
correct.
pretending like he hasn't gotten that far yet.
See, but that's the point
Yeah.
Scalia makes is our obligation is to refer it to the prosecuting authority. If they won't do it, That's no different than them telling Congress to
Right.
pound sand. We're
Right.
not going
Yeah.
to do it. It's we are. If there's an
Yeah.
interdependence
Yeah.
among the branches, that is a feature.
Yeah, I
It's
mean
not a bug.
that's
It's
often
supposed
true.
to be
People are often
interdependent.
unhappy with that. Some of us on the right are often unhappy with that, right? That very few of the powers in our constitutional system are exclusively vested in one of the three branches. There are a few, but not very many. Almost all the power is shared in one way or another.
But
So that's part of the order today is that the parties should brief whether or not a district judge has any authority to conduct this kind of inquiry. If he believes there's a basis to refer a party for criminal contempt, just like you said, it's supposed to refer that to the Department of Justice, and the prosecutors investigate
Right.
and
He
make a
can set forth the
determination as to
basic
whether there's
facts.
a
This is what
prosecutable case.
happened. This was what my order was. It's my view that that this order was maybe flouted in a contemptuous manner. See what you think. That's what he can do. But what is
Right.
so? If you get down to the nitty gritty, and this is what I always would explain to clients, if you get down to the nitty gritty, how is this gonna work? What is Judge Boasberg gonna do? Is he going to accept documents and designate them as courts exhibit number one? Courts Exhibit A. Do you see what I'm saying? Like, who is
but
doing the questioning? Who is marking the
but
documents?
this is precisely Justice Scalia's point,
Right,
that the judicial power is prescribed in the Constitution to involve only cases and controversies, and he views, as I do, a case and controversy versus a case where the judge is the neutral decider in a case involving two or more parties who are opposed to each other. The decider, does not get to put the prosecutor's hat on and take after somebody, or to put the investigator's hat on, the Sherlock Holmes hat, and do an investigation as to what happened. He is a decider and only a decider. That's the argument, and it comes
Yeah, and if you think about it, what he's proposing to do is essentially a shadow quasi grand
right.
jury proceeding.
Or like civil
He's
discovery. He's going to
collecting
hold a deposition
evidence.
in his courtroom at which he's going to
Right.
preside and pose the questions.
Yeah, and now now what would the reaction be if he actually had issued an order to Secretary No to come in and
Right,
explain herself? Now he's using the authority of the court to command her presence, put her under oath, and ask her questions that could potentially involve or
right,
invoke the Fifth Amendment. No different than if well, you can't bring a target into the grand jury and put them under oath and force them to take the Fifth Amendment. That's violation of policy. But so I mean, I think we're sort of
well, it
exhausted this
reminds me
subject,
of
but
that case we talked about recently. Was it in Illinois or in California where one of the judges out there had conducted her own investigation? Remember this? A few weeks, uh, 3 months ago.
Said she talked
oh
to
yeah,
people about it.
yeah.
Yeah,
In Chicago, where she had did she do a site
No,
visit?
she
She did
talked to one of
something
the
to.
officers
Oh
in the
yeah,
court.
involved. She Right. She called the marshals to find out if there'd been any
right.
threats
Yeah,
that required
yeah.
National Guard to
And
protect the
didn't the
the
Court of Appeals
courthouse.
there say that this was inappropriate behavior by this judge?
I'm not sure they got that far. We
Yeah.
all concluded that.
that,
Our Court of
that
Appeals.
did either of you read the Supreme Court case I sent out earlier?
Did you email it? I
Jenkins
didn't see
versus.
that. No. Or did you tweet it out?
I posted it to you and
No.
Chip. Uh,
Let's see.
I've argued this case in a state Supreme Court setting and won it. And it's a case that doesn't get cited much, but it's still good law as far as I can tell. Uh, and has not been cited by the government yet in this case, but it was a 1969 U.S. Supreme Court case dealing with due process issues raised by a state administrative body. Is out of Louisiana. It was a labor management dispute uh, body, and the state legislature appointed a commission to meet and hold public hearings with the ability to call witnesses to testify in public uh, and to determine, based on the facts they heard, whether there was probable cause that persons X, Y, and Z in the union slash management uh, realm had there was probable cause to believe they had committed some violation of either federal or state law.
Oh,
And
so we're just
once they
holding a grand
found
jury in public? That's what we're doing?
a public grand jury on the
Oh
record
God, my God.
with
Oh
witnesses,
my God.
uh, but with the targets of the grand jury having no ability to cross-examine any witness,
Mm,
participate,
mm,
object to
oh
evidence,
my goodness.
present their own side,
Yeah.
etc. And the U.S. Supreme Court in Jenkins versus McKithen, 1969, held that violated those persons who were the targets of that violated their due process rights because
And see, it's
that was in effect a step in the prosecution of those
right,
people
right,
without any ability to participate and exercise their rights of due process. How is what Judge Boasberg proposing to do any different from that?
right. Because who is the secretary's lawyer who's going to participate
Th-
in that and defend her in
they're not
whatever?
even there.
Yeah,
They can't cross-examine witnesses. They can't put on their own case. They're not like a lawyer.
right.
Uh, Bove, for example, is not present in the courtroom. Does not have the ability to defend his reputation.
What's
But
shocking, King, is that like that case had to go all the way to the Supreme Court, right? Before anyone in the system says, you know what, this is not the way we do things here. You can't do it this way.
right, yeah, it's that's not our system.
Right.
Due process requires the persons who are targeted in this process, which is being instituted by Judge Boasberg, everybody who might be tainted by his findings uh, should have a right to have notice of that and a reasonable opportunity to participate and object and cross-examine witnesses
Well, and he hasn't
who
even
come.
gotten that far, right? Because
But
it's
he's
right.
about to. He
Yeah.
would have to
Yeah.
starting
He
today.
would have starting this morning, right? Because he's
Mm.
acting like he's the prosecutor in the grand jury.
But it's not the difference between a grand jury, which is authorized by the Constitution and statute. Uh, it's secret,
Right.
and it's customary under English common law that grand juries could determine there was probable cause to prosecute somebody. So you don't get a right to defend yourself in the grand jury. But when you come to a public proceeding
Right.
with the witnesses on the record with findings by a court or some
Mm-hmm.
uh, uh,
Commission or whatever. Right.
commission or whatever, uh, you're harmed.
Yeah.
They get a hold and throw you in without you having a right to have any say at all.
Right, but so what it boggles my mind always that you're talking about a federal judge. He's been a federal judge for a while. He was a judge in the DC Superior Court before he got on the federal bench. How can you be a judge all this time and it's not just jumping off the page to you that I can't do this way? That it's messed up 6 ways for Sunday.
Well, yeah, I'll tell you why. because one, it's extraordinarily
Yeah.
rare for there to be an indirect criminal contempt case. Now, and an indirect criminal contempt case involving government lawyers and government officials. Um, and the basic affliction of all federal district court judges, which is that 99% of the things they decide never get revisited.
Right.
You know, nobody tells them, they're never
Right.
told no.
Right. And the road goes to their head. Well,
Well, they become kings of their own realm.
yeah.
Is what happens. It's an unfortunate uh,
Yeah.
effect
Yeah.
of becoming a federal judge, and you see it over and over and over again. Uh, Usually, the community that they live in and work in kind of restrains them somewhat,
Yeah.
but something is not restraining Judge
Well,
Busberg.
Well, Chip, to your point, it's going the other way.
except
Right.
in that, yeah, except in
Yeah.
that courthouse. You know, um, Leslie, you've been in that cafeteria. What's that little room off to the side with the door? You know, this is a
Yeah.
big public cafeteria with very good food, but off to one
Yeah.
side there's a door, and the only people that go in
Are the
that
ones with
door
the
are the judges.
robes. Yep. Judge's dining room.
Yeah,
Yep.
yeah. So they all go into that room and they eat, together, and that is an unusual courthouse in that, on the fifth floor is the Circuit
Yep.
Court of Appeals, and on the fourth and sixth floors
Yeah.
are the district
So
judges.
even the Court of
So
Appeals is in
there,
literally in the same building, and that's a little unusual. Yeah.
yeah, so there's like 32 judges in the District of Columbia, all housed under one roof on 7 floors, with a
Yeah.
communal dining room.
No, they're all on top of each other, and it can get a bit incestuous. Although there are, various cliques, not just along partisan lines, but sort of personality lines amongst them. So, but still, yeah, it sometimes becomes groupthink run amok. Um, but it just still is shocking to me that I just think, man, how would I ever find myself in that situation if I were a judge where I'd be like, you know what I'm going to do? I'm going to hold a hearing and I'm going to question the witnesses. Just even thinking about that should tell you, no, you're not. That's not how any of this works. But, they get offended. They
It's
get
kind of,
personally
and it's
offended,
really,
which is also a good indicator that you're doing something you shouldn't be doing.
yeah. I can remember trying cases early in my career, the 90s and early 00s, where, and there's particular judges that I have recollection of, that I knew very well at the time, that they set up, on the bench almost impassive.
Yeah.
They just took in information and didn't participate.
Yeah.
If there was an objection, they would rule on the objection. But otherwise, there was one in particular. This was back in the day before, laptop computers and everything, were ubiquitous through the courtroom. I mean, he just had stacks of, 8 by 14 legal pads that were a foot
Yeah.
tall, all over his desk, and he just took
Took
notes
notes. Yeah. Right.
nonstop, page after page after page after page, and didn't say a word unless something was directed to him.
Yeah. Those days are pretty much gone. When I started practicing, I would say that wasn't 100% of the bench, but it was still at least half. Right? You didn't have so much of this like getting involved directly. They let the lawyers try the cases, and that does seem less to me. What do you think, Steve?
Well, I think they still let the lawyers try cases. There's always been some judges that will get involved somewhat in trials, but to a very limited extent. And when you're, unless they're getting involved on your side, in which you bet you love it, generally lawyers don't like it. They want
Yeah.
to try their own cases. So
Yeah, I just think it was that was much worse at the end of my career than at the beginning. It's eroded, I'd say, over the last 20 years.
Yeah, I think a lot of the erosion, and the lawyers brought it on themselves to some degree. It's an effort to control the direction of the litigation from
Yeah.
A to Z, and the pretrial orders and all of the things that they
Yeah.
employ now to narrow the presentation, sometimes for good reason, but it's just it hems the lawyers in the way they can present the case, and they might have had a completely different idea, and the judge is taken away from them, before you say the
Right.
first word.
So I want to get involved here for a minute, though, because this whole discussion, with which I am largely in agreement, but as a bit of a devil's advocate, I want to pose this. We've been talking about what we as lawyers call indirect contempt, which simply is a lawyer's way of saying a contempt that is committed outside the presence of the court. We all agree that if you do something in front of the judge can haul off and punish you right on the spot for it. That's beyond dispute. So really the issue here is what happens when a judge issues an order and then suspects that somebody has disobeyed it, but it's been outside his or her presence. And uh, I certainly agree that we don't want the judges becoming quasi prosecutors. That's not their role. Um, but it occurs to me that if we take some facts, I mean, a judge issues a temporary restraining order. Like, it's not uncommon that if some historic building or allegedly historic building is going to be torn down, you rush in and seek a temporary restraining order from the court saying, Your Honor, it'll be irreparably harmed. And the judge says, all right, don't tear the building down. Well, if the judge issues an order like that and then somebody tears the building down, I can think of plenty of judges who A, will be pissed, they'll all be pissed, but B, would say, all right, well, we're going to haul in the people
That
who
did that.
did that in front of me, and I'm going to get to the bottom of this, and somebody's going to be in contempt by the end of the day. So if you look at it that way, now having said I can conceive of that, I can't give you any examples that I'm personally familiar with.
Well, what was it that Judge Sullivan was threatening to hold the person in contempt for in Flynn's case? Do you remember when we briefed that?
You got me.
We
I'm
briefed
going
it to the Court of Appeals. Remember? Good grief.
That we briefed the writ of
Yeah.
mandamus issue.
No, but Sullivan was also good grief.
That we briefed the writ of
Yeah.
mandamus issue.
No, but Sullivan was also going to be. He was threatening to hold somebody in contempt. Flynn.
Oh no, he was. Oh no.
Yeah.
Flynn, because he was saying, if I find that he has
right,
Yeah.
lied to the court during the
right,
plea
Right.
colloquy, should that be a
right,
contempt? Should I then
right.
prosecute
Right.
him for
And
criminal
there's
contempt?
Supreme Court law on that says you can't do it.
Can't do it. Right.
Right.
So
I've had this situation, Steve, uh, in my practice come up a couple of times, and the judge asked the question, what do you propose we do, King? And my answer was civil contempt. Both sides can file a brief. We can have a hearing, and you can decide as a neutral adjudicator whether there was a civil contempt, and you can decide on the remedy. Criminal contempt, judge, I think you have to refer it.
right. So that's yeah.
Yeah, and I think and I think that's really where I think where Judge Boasberg has
Hmm.
kind of crossed the Rubicon, so to speak. As the government pointed out in the writ, in the petition for the writ, he found probable cause. He just didn't know who it was. Well, now we've told him who it was, so his work is done. if he wants to refer it, he said he's already found probable cause. He now knows who made the decision. So refer
Which
it.
is why they gave him
But
those
what he
skinny
wants to do,
affidavits, right? He asked for what the people's roles
right?
were. They told him what they gave him the answers for what he asked. But he wants more than
Yes.
that.
Now he thinks he wants evidence of Secretary Nome's
Right.
state of
What the,
mind, and the government's position is, why do you need that? That's
Right.
like for
well,
later.
Right.
That's for the
well,
trial.
that's exactly what happened in the case I was on, where the other side I contended committed contempt of court, and but I was careful to explain to the court because the judge wanted to jump on my side and be the prosecutor, and
Right.
I said, stop,
Yeah.
do not do that. You're the judge. You have to remain the judge. I need you to be the judge.
Right.
You can't be the prosecutor.
I'll explain to you how it's a contempt and then you can rule on it.
Correct.
Yeah.
That's exactly how I handle.
Yeah.
Uh,
Because that's the way it should go. So, I don't understand how judges can not be grasping this point. But I really do understand. It's a rhetorical question. Because the answer is they are so offended that someone has violated their order that somehow they can't see straight. It's absurd. But we see
Well,
it over and over
and
again.
that's
Go
been,
ahead.
yeah. If you've listened to any of the in court proceedings, I'm not saying you have
Mm-mm.
or you haven't, but anybody who has listened, it's clear in Boasberg's
Yeah.
tone that he is
That's what's
angry.
going on. He's offended. Yeah.
All right.
Right. So, they lose possession of their judicial decorum because they're offended. And this is when you start making these
Yeah,
mistakes.
which raises an interesting issue because the government, in their writ of mandamus application in the Court of Appeals, they actually suggested that Boasberg had lost his
Objectivity.
in
Yeah.
objectivity and was biased and had picked a side, and he should be taken off the case. The the appellate court did not address that in their order today, but I suspect that's still out there.
yeah. Now, what I expect they'll do is they will send it back to him. They will not take him off the case. They'll send it back to him, and they'll just simply tell him, "You got to decide, refer or don't refer. That's your choice, but that's all you
Right.
got left."
Right. You made your finding. They told you who the players are. It's not up to you to do a deep discovery dive. So,
And in fact, that the Louis Vuitton, it's an ex-rel Louis Vuitton. I can't remember what the hell the name of
okay.
the case is. But that case, and it's the one that's cited in the order today. In today's order,
Mm,
they cite to
okay,
that
good.
case. So, and that case talks about that it's not the role of the judge to play investigator. That's why you refer it to the
Right.
investigators.
Right. Well, it's Alice in Wonderland, right? Sentence first, trial second is the world that you're in
As,
when.
as I recall, that Supreme Court case, though, Ship, and correct me if I'm wrong, the Supremes left open the possibility that the court, while it couldn't do it itself, could appoint a special prosecutor.
Right.
Correct. Yeah, they did leave open the possibility that because, well, yes, that's where the majority and Scalia
Hmm.
separated. Was Scalia said, yeah, we're just stuck. If the if the Department of Justice won't do it, we're SOL. But that decision does say, yes, that the court can appoint a private prosecutor to conduct the criminal contempt proceeding. It just can't appoint opposing counsel in the pending
Right.
case.
I believe the rule says that expressly too. Uh, that either send it to the DOJ or appoint a special counsel.
I think you're right.
To,
Yeah,
yeah.
I'm pretty sure we included that in our brief in the Flynn case, and that's what I was remembering that from. So, because Sullivan also was proposing to just simply hold a contempt proceeding himself, if I remember it right. Oh, good grief. So,
But that's because if there was contempt, it was done in his
yes,
presence, because the contempt would have been lying to him in the change of plea by admitting to a crime that
right.
later, the defendant says
Yeah.
I didn't commit.
But the case law on that was against him too, because even in that case, as a
Right.
direct contempt, the judge's response has to be contemporaneous. Once the
Right.
proceeding is over, you're in the world of the indirect contempt again, even though the contempt itself took place in the judge's presence.
Yeah, there was one January 6th case with a relatively notorious client who I represented for a short period of time, and for the life of me, I can't even remember his name off the top of my head. But Judge McFadden cited him for criminal contempt, added 4 months to his sentence, while he represented himself at trial, because he referred to McFadden as presiding over a kangaroo court and being a Nazi in in front
Oh
of the
my
jury.
God. Yeah, yeah. Just so you guys know, you can't do that.
Yeah.
Good grief.
except in the
Woo!
movies.
Except in the movies, right? Wow. Okay. Well, so we've got a few minutes left here. King, what was the other issue that you wanted
Well,
to
let's
query Ship about? It was
I wanted Chip to summarize his article today from on Substack, which I found fascinating.
is this the one about Judge Zenas? Or was that yesterday?
or no, the one I just did was the
Oh
warrantless
yes,
Yes,
arrest,
yes, yes.
warrantless
That's
arrest
yes,
it.
for
Yep.
yes.
okay. So this was an issue that I'd seen percolating out there a little bit, and it has to do with criminal or with the criminal with illegal aliens encountered on the street by ICE, and arrest and detention, and whether that could be done without a warrant. And
Right.
there's a statute,
Yep.
Title 8 statute, that specifically says that a warrantless arrest can only be affected when the officer, the ICE agent, can articulate a reasonable belief that the alien will escape if the time is taken to get a warrant. That's my own formulation off the top of my head, but basically, the officer has to have a reason to believe that he can't get a warrant, and
Fast enough.
and because
Yeah.
he would lose the alien in the time period. And so this has been litigated in several courts, and the government has lost
Hmm.
every one of them because the government is using warrantless arrests, um, but not able to back it up with an articulation of why the alien would have likely escaped had the time been taken to get the warrant. Now, what had happened is in the Northern District of Illinois in Chicago, a lawsuit had been filed against the Trump administration in 2018 in the first term for this kind of arrest activity without securing warrants in advance. And the Biden administration, shockingly, entered into a consent decree promising to not do it anymore, to settle the lawsuit. So you have the change of administration. This is not technically one of those friendly lawsuits where it's filed just to get the consent decree. It just happened to change
Mm-hmm.
administration. You had a
Policy.
shift
Yeah.
in policy. The Biden administration wasn't going to arrest anybody, so they were happy to sign a consent decree that said we won't engage any warrantless arrests. Parentheses, we won't arrest anybody in
Right.
parentheses
Now, just so people understand,
of
this is
aliens.
different from where they're going out to detain people that they have orders for already, right?
Correct. It's generally just these
Right.
street encounters where you come across somebody that doesn't speak
Right.
English or whatever, and there's essentially four questions that need to be asked. What's your name? because now you can check ICE databases to see if they've got an A file. Where were you born? And all you're getting them to say is they weren't born in the United States. When did you enter the United States? Best you can determine. And at the time you entered, did you go through an inspection at a port of entry? And if it's like, if they don't have an A file, that means they've never been processed. If they were born outside the United States, then and you give you the date they entered, that's kind of important for certain options depending on how long they've been in the United States. And then were they inspected? If they say no, well,
Right.
you got an illegal alien. You got somebody born outside the United States that's in the United States, was never inspected. They don't have an A file, which means they've never been processed. They don't have a visa,
Right. So
anything
these are
like
people
that.
that ICE is
Um,
encountering in some way. And
in in the Home
right.
Depot parking lot, there's the basic walk and talk encounters, that where they're looking for people who are in the country illegally but don't have a file on them, aren't holding a piece of paper saying, "Hey, that's that
Right. So
guy.
this is
Go
a
grab
different
him."
issue. I just want to make sure people
Um,
understand. This is a different issue from the arguments that you see people on the left raising that these ICE agents can't arrest people because they don't have judicial warrants. This is a different issue altogether.
Correct. They can. Yeah. So these are administrative warrants. And in fact, there's something I didn't know of. It's called an I-220 warrant that is essentially filled out by the officer creating his own
Yeah.
warrant. Now, this is a form that's been created by ICE pursuant to a regulation. Basically, says we are empowering the ICE officer on the street to draft his own warrant by answering those basic questions, filling it out. Now, some judges have said that those are defective or don't recognize them. Warrant has to be issued by a neutral magistrate, even or an immigration judge. So you had this Castanon Nava consent decree out of Chicago that had been signed by the Biden administration in 2022, in May of 2022, and it had a 3-year date, so it would have expired in May of 2025. But the consent decree included a provision that said that it would expire unless there was a pending motion to enforce, meaning that a motion had been filed alleging that the consent decree was not being complied with, and the pendency of that motion would postpone the expiration date. The expiration date was May 3rd, 2025.
So violations wouldn't just go
Shockingly,
poof just because the consent decree had a deadline on it.
correct. Wouldn't become moot by virtue of the consent decree expiring. Miraculously, just by a stroke of luck, somebody filed a motion to enforce the consent decree 3 months into the Trump
Right.
administration in Chicago, and it was filed in mid-April, so it was pending when the expiration date came. And on the basis that there was a motion to enforce pending, the expiration date was continued. So as some ICE enforcement operations, then Operation Midway all went into gear, the immigration rights groups started jumping on, filing a complaint for violation of the consent decree. And so a progressive judge in Chicago that this was assigned to took it up and said, "Oh, you're arresting all these people without warrants when you can't articulate a fear or a reasonable belief that they might escape if you took the time to get a warrant, and you've arrested 600 of them. I find those 600 arrests to likely, I think his language was likely, be in violation of the consent decree, because he couldn't adjudicate every individual case. You would need all 600 arresting officers to not be able to articulate a basis to arrest them without a warrant." I said, "But under the circumstances, I'm going to
Close
file
enough
and
for
find
government
it's
work. I'm going to
likely,
say.
yeah, that you violated the Costanon Nava consent decree in all these cases, and I'm ordering them all released from custody because they're currently in ICE detention awaiting removal." And Seventh Circuit stepped in and blocked that But there are several decisions, including an 87-page opinion written by Judge Howell about 3 weeks ago in the District of Columbia, saying that, look, this is the statute. The government's going to have to comply with it, or these people are going to get released for being improperly arrested and detained. Now, I suggested in my article that, look, this is yeah, okay, you have to have a warrant, fine, but it doesn't take like a 20-page affidavit to secure this warrant. And because these are all immigration processes and this is a civil process, the Department of Justice can create its own regulation for how this kind of warrant gets issued. And they need to come into the 21st century and say, you know what, we're going to allow these warrants to be issued electronically. We're going to allow the agents to simply type into their phone their reasons for why I need to detain this person, and have the warrant turn around and come back to them in 15 seconds from some
from the
number of
appropriate
immigration judges.
ICE official in charge of said warrants. Right.
Right,
Yeah.
right, and they can just because they just need the warrant. They just need the articulated basis put in writing electronically, and then approval come back to them. And they're good. They've got the warrant, and they can make now it's no longer a warrantless arrest. Now it's an arrest based on a warrant. So you don't need to. Okay, so let me back up. I got that wrong. You don't have to articulate why you think the person is going to flee, because that was for a warrantless arrest. Now you're getting a warrant. You just have to articulate that the person is unlawfully in the United States.
So the question then becomes, how long can you hold these people while you're trying to get your warrant?
I think it'd be the same as a Terry stop. I mean, as reasonably necessary. And so that's going to be fact specific.
Ship's proposing an ATM machine for warrants.
Yeah, Steve, I don't know if you can hear him. He said, yeah, Officer Rubber Stamp is going to be issuing these warrants.
One on every corner. Just put in your debit card.
Well, I mean, in the Terry stop situation, which, so people know, is the concept in criminal law that a police officer can, ask you questions, detain you for a short period of time to either confirm or dispel that there are facts to constitute probable cause that you've committed an offense. But it has to be, by its nature, a short interaction, the courts say. So
now this is different, though, because this is not a criminal offense; it's a civil offense. And he's only going to detain you if he has developed, asked the 4 questions that leads him to believe that you're in the country illegally. Now he's got probable cause that you're in the country illegally. Now he just has to go through the ministerial task of securing a warrant based on that probable cause. And if you can do it in 5 minutes over a computer, how is that unreasonable?
What I don't understand is, just thinking through the logic, is how are you also not in possession of sufficient facts from which you could conclude that any rational person is going to flee from this officer, and also put whatever distance they can between themselves and that officer finding them, right? It doesn't actually make any sense.
What is the factual scenario that would lead you to the opposite conclusion, that I can drive away from this person, go back to my office, secure the paperwork, drive back,
they'll
and
still be there, or
at
the address, the fake address that they gave me while I was talking to them, right? It's absurd conclusion that they wouldn't abscond.
I like Ship's idea. Skip that step. Go straight to the ATM. Get your warrant. It's simple.
Yeah.
So we got to do Abrego Garcia quickly.
Okay. I'm game.
Okay, so I mean, did you read the government's opposition to the TRO?
No, I did not.
Okay, so just so we'll recap. We're not going to go back to the start with Abrego Garcia. We've gone through him many times. But last week, Judge Zenas issues a decision that says there's no order of removal. I've asked the government to produce it. They've never produced one. I can only conclude now that one doesn't exist. So because there's no order of removal, there's no basis to have arrested him. If there's no basis to arrest him, there's no basis to continue detaining him. So I'm going to order him removed or order him
Released.
released from ICE custody, and he can go home. He's been in ICE custody in Baltimore since he came up from
Which doesn't
Tennessee.
make any sense. On what basis does she think they detained him in the first place?
Well, she is again. I mean, I don't know if you read the
I did.
Substack I wrote on this
I
2 or
did.
3
Yeah.
days ago. She is just she is gone. She has
Yeah.
lost it.
She has lost the
She
plot.
is
Yeah.
so committed. She's so committed to getting him out of custody and preventing him from being removed. She is just. I mean, the concept of order of removal being a term of art is lost on her.
Right.
It's got to be a document
Right.
stamped
That says
order.
order of removal in bold print at the top. Right.
Whereas when you read the statute, it's clearly a term of
Right.
art. It's just a conclusion. If the judge
The
concludes
immigration judge concludes that.
he's
Hmm.
yeah that he's subject to deportation, that is an order of removal. That's all he
Right.
has to
Literally, you
do.
guys,
It's a
that's what the
conclusion.
statute says. And it says it doesn't even have to be a written order. So why this federal judge doesn't see that is beyond me.
Now, so here's what happens today, though. So then they're concerned. They get an immigration judge to issue on Friday afternoon an amended order removal that says is hereby ordered removed, which is the one thing she says it's lacking. She says because it's lacking, it's not an order removal. Therefore, there's no order removal. So they get an immigration judge to add that to his 2019
Right.
document as a Scrivener's error because the 2019 document says that he conceded
Deportability, whatever that word is. Right.
deportability. He conceded deportability by admitting to the allegations in the notice to appear in
Right.
2019. So it's never been in controversy. So the fact that order removal is left off the document itself is just inadvertent. It doesn't change the intention of the parties and the finding of the judge at the time, and it's a Scrivener's error that can be corrected. So they corrected it. So then they run back in.
The first day
Abrego
was the
Garcia's lawyers.
DOJ. Now this day is Abrego
Right.
Garcia's lawyers. Yep.
His lawyers run back in seeking a TRO from Judge Zenas saying, don't let him arrest him. This is dubious
Dubious, spurious, any
legality.
other us's we can think of.
Yeah. So now, curiously, Judge Zenas, in her order on Friday, says, I'm not taking any position on the appropriateness of this Scrivener's error correction. But you can't arrest him again. And she said, I'm not even sure the government was intending to arrest him because they gave him release conditions that are consistent with the release conditions from Tennessee and blah, blah, blah. So she sort of tries to play it down the middle of the road. Today, government filed a motion for opposition. It said, by the way, Your Honor, you found there's no order of removal. Okay, that means he's still in deportation proceedings. While he's in deportation proceedings, you don't have any jurisdiction.
Right. It's funny how that is.
Yeah. So because he is still in removal proceedings, and now the government said he has the right to appeal the order of removal, but his appeal by statute is to the BIA. And then if he's not happy with the BIA's decision, he can go to the circuit. But because that's the way removal proceedings work, there's no room for you to play here anymore. And oh, by the way, since he's still in removal proceedings, if there's no final order of removal, this is pre-removal detention, which is governed by statute, and you have no authority to play in that decision as well. She checkmated herself by saying there's no order of removal, because by doing so, she booted the whole thing into
Right. She
immigration court.
went past go, do not collect $200. So, it's a do-over. Okay. Well, you're not the immigration judge. So,
Right. And there's all kinds of rules in immigration court about bail
right.
or no bail. And if he doesn't like, and if we put him back in custody pending further proceedings on the order of removal, he's got the right to seek a bail review from the immigration judge. And if he doesn't like the outcome, he's got the right to appeal that to BIA. If he doesn't like the outcome, he's got a right to appeal that to the Fourth Circuit. But there's no step that
This
involves
courthouse.
the circuit, this court. And in fact, while the case is pending in removal proceedings, there's no jurisdiction under habeas, which is the only basis she's got
Right.
it now.
Right. Okay. And
She granted his habeas
right.
relief. She took him out of custody. That
Over.
case is over.
Done.
She
Right.
granted the
He's
relief.
in the immigration court system now. That's where he's at legally. So it'll be interesting to see what she does do, because as we've said many times with this case, the main problem, and also the case with Judge Boasberg, is that these federal judges don't do immigration law because they're not supposed to be doing immigration law, and therefore they don't understand the immigration law.
So Abrego Garcia will come back with, I'm sure, a reply in 2 weeks, and then she'll have a hearing sometime in
Right.
January, and then she won't do anything
Right.
until February. But I would not be surprised to see them just push him right through the immigration courts, right to the Fourth Circuit, and just ignore her at this point.
Yeah, that'll be very interesting to watch. We will be keeping an eye on that. So
I think he's going to have a hard time now. Now that they've just seemed like they're committed. Okay, I think they finally just made a decision. Let's just go back into the
right.
immigration system. Let's get away from
Right.
her. We'll
Give
eliminate the
him his
withholding of
right of
removal
appeals
since we got
back,
to go there.
whatever. Let's just
Right.
march through the process again. Yeah.
Yeah.
Yeah. Because there's no doubt, right? They're deporting him eventually. Yeah.
Yep. Yep.
So, okay. Well, it's been an immigration heavy and contempt heavy evening here. But I think we've come to the end of our discussion. Unless, King, you've got something else you want to offer?
I'm played out here on immigration and contempt. You've exhausted my knowledge.
We've exhausted these topics, right? So I will say that hopefully everyone here can join us over on the Substack. The Substack podcasts, on my Substack, the podcasts, which are like the replacement for these spaces, I'm going to do for free. There's not going to be any charge to that. There is going to be, I am going to have a paywall on part of my Substack, but not for these conversations. So please come over and join us there once I get that up and running after the holidays. And so I will bid everyone a joyful holiday season and say goodnight.
Don't forget JFK now.
Right.
Oh, yeah, I won't. But again, after the new year.
Okay.
All right.
All right.
Good night, everybody.
See everybody
Bye.
later.
Good night, all.